Good morning, everybody. This is Eric Derby. I'm with the Food Shed Alliance, and I am so grateful to have Allison Reynolds and Brian Smith from the State Agricultural Development Committee legal team here today to give a presentation on the Right to Farm Act in New Jersey. This is part of an ongoing workshop and training series for beginning farmer ranchers that the Food Shed is putting on. We'll announce those workshops and training sessions as they come up in the months and years ahead. For today, I'd like to just talk about if you have questions, we're going to ask you to put them in the Q&A section instead of a chat session. You're welcome to talk in the chat as well, but it's easier for us to answer your questions from the Q&A. So I'd like to introduce Allison Reynolds, who's going to be giving the presentation today, and turn it right over to her. So thank you so much, Allison.
Thank you, Eric. As Eric said, my name is Allison Reynolds. I'm an attorney with the State Agriculture Development Committee, or SADC, and I am also the main contact for Right to Farm inquiries with the SADC. As Eric also noted, Brian Smith is also on the line. He is the Chief of Legal Affairs for the SADC. He will not be making the presentation today, but he's on call in case anything I say needs to be clarified. And he is also there to field questions as you type them into the Q&A box. So to get started, this is the Right to Farm Act in New Jersey. So just to be clear, it only applies to farms in New Jersey, not in Pennsylvania or any other state. The Right to Farm Act provides two types of protections for eligible farms. One is if a farm receives Right to Farm protection, that farm has the ability to preempt local ordinances pertaining to that protected activity. The other type of protection that can be afforded under the Right to Farm Act is protection from neighbor and municipal nuisance suits. As you can see on the screen, if a farmer receives Right to Farm protection, she or he has an irrebuttable presumption that that protected activity does not constitute a public or private nuisance. In other words, what that means is if a neighbor or a municipality brought that farmer to court claiming a nuisance for the activity that received protection, the farmer can assert the Right to Farm protection as a defense that it's already been found that this activity does not constitute a nuisance. This next slide illustrates why we have the Right to Farm Act in New Jersey. Right there, it's the Lee Turkey Farm, nice looking farm in East Windsor, Mercer County. But then when you pan out, you see a large number of residential and commercial competing uses. In such a densely populated state, there are a lot of competing interests right next to the farm. And so the purpose of the Right to Farm Act is to ensure that responsible farmers are not being negatively impacted by these competing interests right next door. There are a couple processes that are contemplated under the Right to Farm Act. The first is the conflict resolution process, under which a neighbor or township that has an issue with an activity going on the commercial farm can file a complaint with the CADB. And at the outset, I just want to clarify, I will be saying a large number of acronyms here. CADB is the County Agriculture Development Board. Those are the entities in the counties that first hear Right to Farm matters. Every county in the state has a CADB except for Hudson, Union, and Essex. And if right to farm matters arise in those counties, the SADC will hear the right to farm matter in the first instance. The second process provided for in the Right to Farm Act is the site-specific agricultural management practice request. This is an affirmative process. So even if there is no complaint against the farmer can proactively request the CADB, provide her or him for right to farm protection for a particular activity. And if she or he receives that protection, it is in place so that if future issues arise, the farmer can already have that right to farm protection in place and assert it. There is also what may happen in these right to farm proceedings is a combination of the two. So we have seen instances where a neighbor will file a complaint against a farmer and get the right to farm process started with the CADB, but then the farmer will request a site-specific agricultural management practice or SSAMP in order to receive the right to farm protection for that activity and defend him or herself against that complaint. On that last slide, what I went over were the more formal processes under the Right to Farm Act. There is also an alternative process, which is the Agricultural Mediation Program, which we at the SADC administer. It's a nice alternative to the formal right to farm process. And basically, if somebody requests mediation from the SADC, we will try and gather all of the interested parties to that dispute, put them together with a mediator, which we have a list that gets approved on an annual basis. And the mediator can assist the parties in narrowing the issues and coming to the best result for everybody. So this mediation program, it's a nice alternative. It's free, it's voluntary, it's confidential, and takes up much less time and is a lot less costly than going through the formal right to farm process. So complaints against commercial farms. Under the Right to Farm Act, the CADB is the first entity that must hear a complaint against a commercial farm. You will see the language of a section of the act up there, which says any person aggrieved by an operation of a commercial farm shall file a complaint with the CADB prior to filing an action in court. Despite that rather clear language in the law, we often will catch wind of towns filing complaints in municipal court when they claim that an activity the farm is doing violates a local ordinance. And in that instance, we will submit to the municipal court judge a memo, much like you are seeing up on the screen, where we go through the case law interpreting the Right to Farm Act that makes it clear that the CADBs have the primary initial jurisdiction over right to farm disputes. And when we've hardly ever seen an issue with that, typically when the judge sees that, the matter will get dismissed at the municipal court level and it will proceed with the CADB. So again, CADBs have primary jurisdiction over right to farm matters. We also hear municipalities or neighbors say, well, clearly, in our opinion, it is not a commercial farm. It doesn't meet that eligibility criteria, so we'll just go ahead to court anyway. Well, the response is that under the law, it is up to the CADB to make that determination whether or not the commercial farm qualifies, is eligible for right to farm protection. again, it is up to the CADB to decide in the formal process, not for people to just make other entities to make the assumption that the farm does not qualify for Right to Farm under the Right to Farm Act. On this slide, there are a couple of appellate division cases that have discussed and supported this idea that the CADBs have primary jurisdiction over farms, and that they are the ones that first determine whether or not a particular farm or activity on that farm qualifies for right to farm protection. There are a number of criteria that the farm needs to meet in order to even qualify for right to farm protection. So I'm going to go through the next few slides on these different threshold criteria and the determinations that the CADB or the SADC, if the case may be, need to make. The first criteria is that the farm must meet the definition of a commercial farm as that is set forth in the Right to Farm Act. That definition states that the farm management unit, if it is 5 acres or greater, must satisfy farmland assessment criteria and produce products worth $2,500 or more annually. If the farm management unit is less than 5 acres, it must otherwise satisfy the farmland assessment criteria, aside from the size requirement, as 5 acres is required under the Farmland Assessment Act, and produce products worth $50,000 or more annually. So there's a higher production amount under the smaller farm management unit standard. Finally, and this was a recent-ish amendment to the Right to Farm Act from probably 6 or 7 years ago. If the farm management unit is a beekeeping operation producing honey or other agricultural or horticultural apiary-related products or provides crop pollination services, it needs to demonstrate that it is producing products, these types of products, worth $10,000 or more annually. And we're going to get into what a farm management unit is and what you look at in making that determination under the farm management, under the Right to Farm Act. But I first just want to point out that because this is something that gets misconstrued with right to farm issues, that the farm management unit doesn't actually need to be farmland assessed, but it must be eligible. It must be clear that it could satisfy the criteria for farmland assessment. Okay, so how is a farm management unit defined under the Right to Farm Act? It is a parcel or multiple parcels of land, which can be contiguous or non-contiguous, including the buildings, structures, and facilities located on the land, producing agricultural products, and it must operate these different parcels and portions of the farm management unit must operate as a single enterprise in order to be considered one farm management unit. In 2012, the SADC issued a final decision in the Sipos v. Hunterdon CADB matter, where we provided examples of the evidence that you need to look at to show that operations are running as a single enterprise. Looking at LLC formation documents and operating agreements, tax records and tax returns, integrated business resources, seeing if there's centralized accounting among the different parcels and entities involved, profit and loss allocations, whether there are separate bank accounts. So it's a very fact-specific inquiry, but it needs to be demonstrated that everything is being operated as a single enterprise. So couple years ago, we had a case, the Mville decision in Monmouth County, where we really narrowed in on the single enterprise issue. So in this particular case, the town filed a right to farm complaint against a landscape and nursery business, claiming that they were conducting an illegal recycling business. And the landscaping business asserted that they they entitled to right to farm protection and that they were considered a commercial farm. And just to give you the facts here, what was involved was two contiguous lots, 1 6 acres and 1 7 acres, each farmland assessed and both owned by this landscaping business, which happened to be an LLC. One of the parcels, the landscape and nursery business was located, plus there was 2 acres of wheat production. So not too much agricultural production going on that parcel. The other parcel was leased to a separate farm business entity. And on that parcel, there was 5.5 acres of hay production. And that tenant farmer used the sale proceeds from that production for its own purposes. Looking at this type of scenario, we determined that there was no evidence that the landscape business and the tenant farmer farm business were interrelated enough, and in order to be considered a single enterprise, as the parties' business arrangement appeared solely to just, the only benefit, I guess, in other words, that the landscaping business was receiving as being the owner of that parcel was getting the farmland assessment tax break by virtue of the production occurring for a separate business. So this is a good case to look at if you have questions about the single enterprise condition, because like I said, it's probably the deepest dive we've ever taken into that requirement under the commercial farm definition. The second criteria is location. The farm needs to be located in an area where agriculture is permitted, or alternatively, it needs to be demonstrated that it was in operation as an agricultural operation as of July 2nd, 1998, and continuously thereafter. So kind of a grandfathering provision if it's not permitted by the town in that zone. The third criteria is that the activity for which the right to farm protection is sought must be included in the list of protected activities which are set forth in the Right to Farm Act under NJSA 4:1C-9. We sometimes refer to them as Section 9 activities. And next, I'm going to be going through a list of these protected activities as set forth under the Right to Farm Act. The first is probably the type of activity we see most often for which protection is sought under the Right to Farm Act. Just the straight up production of agricultural and horticultural products, trees and forest products, livestock, and poultry and other commodities that meet the classification. I think it's standard industrial classifications for agriculture, forestry, fishing, and trapping. Second type of protected activity is the processing and packaging of the agricultural outputs. So, it's a farm where apples are being produced, the processing of those apples into applesauce or pies and the packaging of them, that is potentially protected activity under the Right to Farm Act. The operation of a farm market, which can include the construction of building and parking areas, but under the Act, those need to be, the building and parking areas need to be constructed in conformance with municipal standards. replenishing soil nutrients and improving soil health, controlling pests, predators, and diseases of plants and animals. The photo up on the screen would fall under this type of protected activity because it's putting up deer fencing. Clearing woodland using open burning and other techniques, installing and maintaining vegetative and terrain alterations, and other facilities for water and soil conservation and surface water control in wetland areas. Conducting on-site disposal of organic agricultural waste. Conducting agriculture-related educational and farm-based recreational activities. Kind of an agritourism is a word we see sometimes that would fall under this category. However, those types of activities can only be protected if they are related to marketing the agricultural or horticultural output of the farm. So there needs to be that connection made between marketing the product and that type of activity in order for it to receive protection. Engaging in the generation of power, heat from biomass, solar, wind energy, provided that this type of energy generation is consistent with SADC rule and regulations. This next protected activity is actually comes from the most recent amendment to the Right to Farm Act from the beginning of 2021, allowing for the housing of full-time year-round equine-related farm employees if the housing is in the same building or facility as where the horses are housed. And just to point out there that, again, the housing can only be for full-time year-round farm employees. It would not provide protection for housing for migrant, seasonal, or temporary employees. And finally, a catch-all that the SADC may adopt by rule agricultural activities to be protected under the Right to Farm Act. The fourth criteria in order to even qualify for Right to Farm protection is compliance with applicable state and federal laws and regulation. Again, that word applicable, it's not required that the CADB look and make sure that every single state and federal law that applies to that property, whether it's related to the activity for which protection is sought or not, is in compliance. It's just only need to look at the particular state and federal laws that would apply to the activity that is the subject of the right to farm matter. Examples of state laws that we see in different right to farm matters that cannot be preempted include the state's stormwater management rules, the Uniform Construction Code, which applies to buildings. This is something that can come up with a farm market facility, for instance. The Uniform Construction Code, or UCC, is a state law, and therefore the requirements of that law cannot be preempted. If there are freshwater wetlands violations that are related or applicable to the subject matter of a particular right to farm issue, those cannot be preempted. And again, animal waste management, that's based on state law. So the regulations with regard to the state animal waste management law cannot be preempted. The fifth criterion that needs to be determined in order to receive right protection is it needs to be clear that the activity does not pose a direct threat to public health and safety. By way of example, if a community-supported agriculture operation or CSA is seeking right to farm protection for it's the activities occurring in conjunction with that CSA on the property. If the entrance, exit, driveway onto the public road creates a traffic hazard, then that comes out of the CADB does not have jurisdiction over that particular issue because of the implication it has to a direct threat to public health and safety. The sixth criteria under the Right to Farm Act is that the subject activity must conform to generally accepted agricultural management practices. With regard to generally accepted agricultural management practices, the SADC has adopted 13 by regulation. Examples are, there is a tree fruit AMP. I think I'm going to go through a list on what our AMPs are, so I'll save that. But there are 13 adopted agricultural management practices by regulation. The farmer can also seek a site-specific agricultural management practice. So just because a particular activity for which you are seeking right to farm protection isn't covered by one of the adopted AMPs, you still have recourse because you can request a site-specific agricultural management practice. All right, here is a list of the agricultural management practices or AMPs that have been adopted by regulation. AMPs pertaining to apiaries, poultry manure, land application of food byproducts, commercial vegetable production, commercial tree fruit production, natural resource conservation, on-farm composting, fencing for wildlife control. Again, there's that deer fencing, equine activities, aquaculture, solar energy generation, on-farm direct marketing, so the farm markets and the activities involved with that, and pick your own operations. So again, since state law and regulations cannot be preempted by the Right to Farm Act, they must still be complied with by the commercial farm. And even if that state law enforcement has been delegated to the municipality or county, just because a local entity is enforcing it, it still needs to be complied with because it is still, at the end of the day, state law. However, if the municipality or the county has requirements that exceed the standards of the state law, those standards could be preempted to the extent that they exceed the state law. So for example, if a municipality has a stormwater management ordinance that requires a 1,000-foot setback to a Category 1 stream, when the state law only requires a 300-foot setback, the amount to which the municipal ordinance exceeds that 300-foot setback, that could be subject to preemption. Another example is if a municipality adopts a septic code that exceeds the state standard by requiring more than 10 feet to groundwater. However, even though local laws can be preempted by the Right to Farm Act, the CADB needs to still give due consideration for those local laws and balance the local law with the farmer's legitimate need to engage in the agricultural activity. And if a particular issue is too complex for the CADB, they may defer that issue back to the municipality. So local laws that are based on health and safety issues. This was discussed in some case law interpreting the Right to Farm Act. The Supreme Court in the Den Hollander case recognized that although CADBs do have primary jurisdiction over disputes between municipalities and commercial farms, they do not have carte blanche to just make whatever determination they feel is they want to do with that commercial farm. The CADB's authority is not unfettered. And when they are considering disputes that directly affect public health and safety, they must consider the impact of that practice with those public health and safety standards in mind. And again, it's said later in the Supreme Court opinion that the CADBs are required to consider the impact of municipal land use ordinances when there's a public health and safety issue involved, deferring to the municipality when appropriate. So, in other words, agricultural activities may preempt municipal and county regulations. However, the CADB must always provide appropriate consideration and deference to those local standards. So this illustrates the balancing test that the CADB must undertake when it is considering a right to farm matter. Balancing the agricultural needs against the municipal public health and safety concerns. And further, the farmer must show a legitimate agriculturally based reason for not complying with the municipal regulation. With these local public health and safety standards in mind, site plans are often required. So again, review of site plan elements is often needed, particularly for on-farm direct marketing facilities that are open to the public. Public health and safety concerns are obviously at play in those types of issues. So the CADBs still have primary jurisdiction over the regulations, and when a SSAMP or site-specific agricultural management practice request is made. However, the complexity of the site plan review process might exceed the financial and technical capabilities of the CADBs. And furthermore, if the site plan includes certain elements related to state law, like Uniform Construction Code standards, Americans with Disability Act requirements, other state laws like stormwater management, the CADBs do not have statutory jurisdiction to even review those elements. So when site plan review is involved, the farmer has a couple of options. The farmer may apply to the CADB for a site-specific agricultural management practice. And the CADB can give approval of many of those site plan elements. Again, based on the previous slide, if it's a state law involved, they don't have jurisdiction over those elements. And if it's a complex public health and safety issue, they may defer to local review for those other elements. The other option the farmer has is to apply to the municipality for site plan review initially, and then later seek relief from specific elements of that site plan with the CADB after it has received it from the municipality. CADBs and/or municipality can waive or reduce requirements based on site-specific considerations. Site-specific considerations include scale, the intensity of the use, the farm setting, what type of other uses are occurring on the neighboring properties. any roads, again, kind of that CSA example we gave beforehand, what public safety concerns are come up because of that site-specific consideration, and any minimum improvements needed for safety. So this slide kind of provides a flow chart of how right to farm matters are processed and the procedures they go through. So initially, the CADB will hear the matter and issue a decision, whether it is a complaint or a site-specific agricultural management request. If anybody finds themselves aggrieved by the CADB's decision, they can appeal it to the SADC. And there are different time limits on appeals. In complaint matters, the appeal needs to occur within 10 days of receipt of the CADB's decision. For SSAMP requests, the appeal period is 45 days from receipt of the CADB's resolution. For the most part, what the SADC will do once it receives a timely appeal is forward the matter to the Office of Administrative Law, where there will be a hearing, and an administrative law judge will take testimony, look at evidence, and eventually issue a decision, which is referred to as an initial decision under the Administrative Procedures Act. Then that initial decision will get reviewed by the SADC, and the SADC will look at, we look at everything. We look at what occurred at the CADB, what the record was in front of the CADB, meeting minutes, we'll sometimes get a transcript of the hearing in front of the Office of Administrative Law, look at all the evidence produced during the Office of Administrative Law hearing, and then we will eventually issue a final decision where we adopt, reject, or modify the different parts of the administrative law judge's initial decision. As again, usually when the SADC begins the hearing on the matter, it first occurs at the Office of Administrative Law, and then eventually the SADC will issue a final decision, which is a final agency action. If there are parties that are aggrieved by the SADC's decision, they can then appeal the decision to the appellate division of the Superior Court, and that time to appeal is 45 days from the date on which the SADC's final decision becomes a final agency action. Again, and then if somebody is aggrieved by the appellate division, they could petition the Supreme Court for the Supreme Court to hear it. But that it's very rare that the Supreme Court will actually take a case up on appeal. And I believe Den Hollander, we've only had one right to farm matter that actually went to the Supreme Court. So that last slide was a flow chart of the formal right to farm process. Again, want to put in a plug for our agricultural mediation program, which is the more informal way to resolve conflicts. And it's a free service offered by the SADC. Again, nobody is required to go through the mediation process, but if they choose to, we will place them with a trained impartial mediator who will meet with the parties and hear the parties out, hear their different points of view and the interests involved, and help them narrow the issues in order to look for solutions. I always think the best saying I've heard is the best outcome is when all parties are equally dissatisfied, because there's really no winners or losers in the agricultural mediation process. Everybody comes to consensus on what seems to be the best solution for all parties. And again, we strongly encourage the use of the mediation process before engaging in a formal right to farm process. It's confidential, it's free, it's much quicker and more affordable than going through the right to farm process. So if it's possible for the dispute to get resolved through the mediation process, we strongly encourage that. All right, these next few slides will focus on our on-farm direct marketing agricultural management practice, which provides for farm markets and as well as marketing events. So that definition is pulled from our on-farm direct marketing agricultural management practice. It means agricultural related functions that are accessory to and serve to increase the direct market sales of the agricultural output of the farm. The purpose of these events, and it needs to be clear, this needs to be found by the CADB, they must be designed to attract customers to the farm by enhancing the experience of purchasing the agricultural products. They may include on-farm direct marketing activities as components. They may be product-based or farm-based, and they can only occur seasonally or periodically. So a permanent, regularly scheduled event that could not qualify for right to farm protection. There needs to be that seasonal or periodic component. Here are some examples of on-farm direct marketing events that may be able to be protected under the Right to Farm Act, provided that they demonstrate the required relationship to marketing the farm's output. So an agricultural product festival at a farm, this is an example of a product-based event. So if the farm is producing apples and has an apple festival or a blueberry festival during the time the blueberries are being harvested, that is an example of an agriculture product festival. Seasonal harvest festivals at a farm producing such seasonal products are an example of an event that could be protected. We see that photo up on the screen of Halloween pumpkins. So, a farm produces pumpkins and they have Halloween type of events or fall festivals because they produce that type of seasonal product at that particular farm. These next couple bullets pertain to farm-based events, farm open houses to invite members of the public to look at what is going on that farm, what is being produced. If the farm has a community supported agriculture program or CSA, membership meetings, CSA membership meetings are examples of events that, could qualify for protection under the Right to Farm Act. Farm to table events that showcase the farm's agricultural output. So farm to table events, again, they may be protected if it can be demonstrated that there is a relationship between that farm to table event and the output, marketing the output coming from the farm. So just a really basic example, if a farm holds a farm to table event and it and I'm going to apologize for to the vegetarians out there, but if it's they're having steak and potatoes, but they don't actually produce the cattle and they don't produce potatoes, but they produce rosemary and they have one sprig of rosemary on the steak, that doesn't cut it. that farm to table event isn't actually showcasing the farm's agricultural output, because it's such a small the farm's agricultural output is such a small component of that farm to table dinner. But if on the flip side, if the farm is raising that cattle and producing those potatoes, it is feasible that that type of farm to table event could be protected under the Right to Farm Act. The on-farm direct marketing agricultural management practice provides a number of general provisions to guide the CADBs into what is generally accepted. So one component that the AMP gets into is hours of operation. The general hours of operation must be between 6 a.m. and 10 p.m., although under certain circumstances may be extended to 11 p.m. There are lighting requirements. The farm, in order to get the right to farm protection, must provide lighting when if it is open after dark. Safety. The commercial farm is required to provide visitors with any market related rule and safety procedures. May include notice that the visitors should use common sense, be aware of inherent risks, and wear farm appropriate attire. Some other general provisions that are set forth in the on-farm direct marketing AMP. Sanitary facilities. The commercial farm must provide such type of facilities, such as restrooms or porta potties, if it is providing seating for eating, if activities or events promote people staying on site for more than 90 minutes, or if required by state law under the state retail food code or the uniform construction code. There are provisions related to signs. Signs may receive right to farm protection under the AMP, but there is a maximum sign size of 16 square feet, and the overall combined footage of all signs cannot exceed 160 square feet in order to get the right to farm protection. Parking at the facility must conform with municipal standards. That it comes from the Right to Farm statute itself under the Section 9 protected activity for farm markets. If there are no municipal standards applicable to the type of facility, then there are standards set forth for parking in the agricultural management practice regulation itself that would apply. The AMP also provides buffers for setbacks and screenings that may be used if the CADB determines that's necessary when it balances the impact of that operation on the neighbors. The AMP provides setback standards for new or expanded on-farm direct marketing facilities. I believe for new, it's 50 feet setbacks. Additional provisions under the on-farm direct marketing AMP. Existing and new structures or improvements may be used for activities and events. However, with existing structures, the only way they could qualify for the protection under the on-farm direct marketing AMP is if it is determined that the use for the on-farm direct marketing activities in that existing facility does not adversely affect the continued use for of that facility for agricultural production. So again, all these standards keep in mind that the primary use of that farm needs to still be for agricultural production, but we recognize these different marketing activities that benefit the farmer by helping market the product produced on that farm. New facilities may be constructed as long as construction and use of that facility have negligible impact on continued use of land for agricultural production. So if if somebody is seeking to build an on-farm direct marketing facility in the middle of a productive farm field with great soils that would have the effect of taking a lot of land out of production, that probably would not be eligible for right to farm protection. Land use activities and events, you know, such as pick your own operations or something like that, shall have negligible impact on continued use of the land for agricultural production. Overnight lodging is explicitly not protected under the Right to Farm Act. We've gotten inquiries from people asking if, as kind of a part of a agritourism type of component, they can allow people to camp on the farm. That is something that is not protected under the Right to Farm Act, under the On-Farm Direct Marketing, AMP. So farmers may request site-specific agricultural management practices for these marketing activities, which is fine. But they must be, at the very basic level, must at least be consistent with the agricultural management practice. Again, that provides the rules for what the SADC considers to be generally accepted with regard to on-farm direct marketing. Events. The on-farm direct marketing AMP provides for event management plans. If the farm is having a large event with significantly more traffic and visitors than what is normally occurring on the farm, that farm needs a plan for addressing potential public health and safety issues, such as emergency vehicle access, traffic management, and other potential public health management issues. If a plan is required, it must be in writing and provided to the municipality at least 30 days and in advance of the event. And the purpose of providing this plan to the municipality is as an advisory notice and to enable the municipality to coordinate with the farm for addressing these different traffic management and public health and safety issues if necessary. As an alternative, the farmer could also get a special events permit from the town if the town has a provision for such permits, rather than going through the right to farm requirements for event management plans. We get this question somewhat frequently. Are celebratory life events such as weddings, graduations, birthdays, and anniversaries eligible for right to farm protection? And what is up on the screen is we addressed this question when we adopted the on-farm direct marketing agricultural management practice. In response to a comment where this question was asked, we stated that most of these sort of celebratory events would not meet the definition of an on-farm direct marketing event, because they wouldn't be a marketing tool employed to attract customers, in order to market the product. That underlying portion of the comment is important. While it is conceivable that an event such as a wedding could be protected as a type of retail marketing event, provided that an overwhelming majority of the food and beverages served were produced from the output of the farm, the SADC believes that protecting such uses would require promulgation of a separate AMP to address the conditions under which right to farm protection could be available. So in other words, we really don't see at this point the authority for right to farm protection for those types of activities. All right. So next, we're going to go through two particular right to farm cases. we're calling them Reich Farm case studies. The first one is Hampton Township v. Brodecker Farm, and this case was about a farm market located on the farm. So we'll kind of get into more details of the products in that market and what was found to be protected under the Reich Farm Act and what was not. So for background, here the farmers sought Reich Farm protection for the products sold at the farm market, which included livestock shelters, and muck boots and fencing supplies. It was a pretty broad range of different products being sold at that market. And it was, I believe it's a livestock farm was the production occurring. And the township opposed the application. The township argued that certain aspects of the farm market violated local regulations. And additionally, there was also a neighbor complaining of the increased traffic and aesthetic, and the neighbor also had aesthetic issues with the farm market's appearance. So getting back to the definition of a farm market under the Reich Farm Act, it is a facility used for the wholesale or retail marketing of agricultural output of the commercial farm and products that contribute to farm income. Except that if a farm market is used for retail marketing, at least 51% of the annual gross sales of the retail farm market shall be generated from sales of agricultural output of the commercial farm. So we're going to get into that 51% annual gross sales requirement in the next couple slides. So what type of documentation do you look at to demonstrate this 51% of gross sales standard? In this particular case, the farmer provided a profit and loss statements that only contained percentages of the income generated from the sales of the farm's agricultural output, but not actual dollar figures or other proof of cash receipts. So it was kind of a summary look at what they were doing. And when this matter got appealed and went to the Office of Administrative Law, the administrative law judge placed the burden of proof on the township to show that the farmer was not actually selling 51% of that the 51% of the products weren't actually coming from the output of that farm. And therefore, the ALJ upheld the CADB, which had granted right to farm protection for this farm market based on that evidence. So when the SADC got the case and looked at the administrative law judge's initial decision, we observed that the administrative law judge did not undertake any analysis of those profit and loss statements. And we emphasize that because right to farm eligibility is dependent on the 51% gross sales requirement, here compliance with this requirement is central to the integrity of the Right to Farm Act process. So in other words, given how important that particular provision was, it needed a more thorough analysis than what the ALJ gave it at the Office of Administrative Law. However, we also recognize that farmers may not want to completely open up their books to the CADB and may prefer not to disclose every detail of their operations income. So in the SADC's final decision, we balance the commercial realities, the farmers' interests, and not disclosing everything about their operation with the integrity of the Right to Farm Act program that, we need to be able to thoroughly look at these very specific requirements in the Act. And we found that the operation met the definition of farm market, but subject to the farmer obtaining an attestation report from a CPA to review the data of the profit and loss statement percentages, review the data from which the profit and loss statement percentages were based, and to confirm that the 51% standard was met. So what we just went through was the 51% of gross sales coming from the output of the farm requirement under the farm market definition. Another portion of that definition states that um, the farmer can also show that 51% of the sales area must be devoted to the sale of the agricultural output of the commercial farm in order for that market to get right to farm protection. So the documentation that was provided to support this 51% sales area standard under the farm market definition. The farmer provided a plot plan showing buildings and areas categorized as direct farm market sales and storage and non-farm and farm produce products sale. And the CADB essentially found that any area of the farm at which a customer selects livestock or picks up hay or grain constitutes a farm market sales area. And again, going to the Office of Administrative Law, the administrative law judge placed the burden of proof on the township to show that that sales area was not devoted to the product, the output of the farm, and finding that the township did not meet its burden of proof, the ALJ upheld the right to farm protection. So getting to the SADC's analysis and the final decision for this matter. A sales area must be predominantly used for marketing of the commercial farm's agricultural output. And this is also set forth in the on-farm direct marketing AMP definition. We noted that although occasional customer access to livestock holding pens to inspect for potential purchase and storage structures for pickup did not meet the statutory definition of sales area, they were entitled to right to farm protection as a generally accepted agricultural management practice as components of the retail operation. Areas and structures not predominantly used for the marketing of the farm's output, such as livestock holding pens and areas where just the commodity was just merely a pickup site, we found that they were not considered sale areas and therefore could not be factored into this 51% gross sales area standard. And without including those areas, the farmer or that the farmer could not meet the 51% gross sales standard by not including those areas. The next component of the farm market definition we're going to go through is whether the facility is used for the wholesale or retail marketing of the agricultural output of the farm and products that contribute to farm income. I think the determining what the retail marketing, what the output of the farm is pretty clear. If the farm produces blueberries and it sells blueberries, that is the output of the farm, by way of example. But what are products that contribute to farm income? Under the on-farm direct marketing AMP, complementary products are defined as items commonly used to facilitate the use or consumption of the agricultural output of the commercial farm and promotional items that help market the commercial farm. So with the first part of that definition, items commonly used to facilitate the use or consumption of the product. For example, if the farm is producing nursery stock, providing ornamental plants, selling products that would help with the consumer with, actually placing those plants in the ground at their homes, such as, garden shovels, soil, that is something that could be a complementary product. Additionally, there's also promotional items that market the commercial farm itself are also considered complementary products. So souvenir items such as commercial farm branded shirts, hats, and bags, those would be considered complementary products that could receive protection under the farm market definition. Supplementary products means the agricultural output of other farms and additional customary food and drink items. One of the examples I thought of for this was, we had previously talked about in our on-farm direct marketing slides about fall festivals, for instance, as an event that could be protected. If, apple cider produced from other farms, that could be a supplementary product, as it is a customary drink item for that particular type of event. So here is a list for this particular case of the products that were sold at the market. Livestock shelters, animal feed, fertilizer for crops, feeders, manure spreaders, tractors, fences and fencing supplies, muck boots and gates. As you can see, that's quite an array of different types of items being sold at the market. So we're going to go through and discuss what items were protected, what weren't, and why. So here's a list of the protected items. Animal feed was protected because it was produced from the output of that farm, and the feed was also processed from that farmer's farm-grown products. The crops that farmer actually produced, such as hay, corn, and oats, and wheat, that was protected. The livestock raised on that farm, the beef, swine, and poultry were protected as the output of that farm. Seed was protected because it came from that farmer's sunflowers, and so was the output of that farm. And if there was seed from other farms, it was protected as a supplementary product, a product from another farm that contributes to the farm's income. These items were items that were found to be conditionally protected. Items protected as products that contribute to farm income because of the reasonable connection to the sale of the farm-raised livestock sold for continued raising of the livestock from that farm. And the protection was conditioned on the type and scale of the items sold being consistent with the type of livestock sold at that farm market. So livestock shelters, livestock supplies, livestock feeders, waterers, fences, gates, so long as they were actually related to the type of livestock produced on that farm, they could be protected. And this is kind of in line with that gardening supply example I gave earlier for a farm that produces ornamental plants. These items were found not to be protected in the farm market. Gazebos, as we could not find a relationship between that item and the farm-grown agricultural output sold by the farmer. Garden sheds, again, there was no relationship between that item and the output produced from the farm. There was this request for just related equipment, and that was so vague. There was not enough evidence in order to assess, whether that could be protected. Again, these are very fact-specific inquiries, so understanding the details are required in order to provide these different items with right to farm protection. Tractors and trailers, those products were found not to be protected because the phrase products that contribute to farm income does not contemplate that a commercial farmer would be a sales dealer of agricultural motor vehicles, implements, or attachments thereto. We thought that went beyond the scope of the Right to Farm Act. Other items that were not protected, fertilizer and lime, as there was no evidence that those materials were produced as the farm's agricultural output. And again, we didn't find any complementary or supplementary connection to the sale of the farm's livestock with fertilizer. Hay wagons and manure spreaders, much like the reason that we found that tractors weren't protected, is we thought that that went beyond the scope of the Right to Farm Act, because we didn't think that products that contribute to the farm income didn't contemplate a commercial farmer becoming a sales dealer of these motor vehicles. All right, so that was the sort of farm market case study. This next case study is of in the matter of CLC. It's a decision we issued in 2020, I believe, and Monmouth County case. And this, the reason we have it up here is to kind of dig deeper into the commercial farm definition. And this case also might have some valuable lessons for a new farm, because this farmer sought right to farm protection just 4 months after acquiring the farm. So by way of background here, nursery operator purchased a farm on which they imported ball and burlap plants and then nurtured those products by periodic watering, pruning, and fertilizing. And the nursery operator applied for right to farm protection for the nursery operation and a sales center, again, just 4 months after purchasing the farm. And this application was opposed by both the township and the neighbors. A few more details about this particular operation. The plantings began in February 2014, and the SSAMP application was filed in May 2014. So just 3 months after plantings began. However, the growing season for these plants was for a period of at least 7 to 8 months. There was an insufficient period of time to actually effectuate the sales of these products. So there was no sales receipts for these products. To restate the commercial farm definition, it requires for farms that are 5 acres or greater, which this farm was, there needed to be at least $2,500 worth of, the farmer needed to show that they were producing products worth at least $2,500 in order to qualify for right to farm protection and meet that commercial farm definition. So here, well, in most cases, when we look at that commercial farm definition, we do look at sales receipts because the farmer has sold its product, and that's a pretty easy way to demonstrate that they meet that production requirement. So here in this case, when the farmer hadn't actually sold any of its product of the farm, the question then became, was there alternative evidence of production value to determine commercial farm status? With this regard, we want to point out that the commercial farm definition that specifically states that the agricultural or horticultural products produced from that farm must be worth $2,500 or more annually. It's not that the farmer must realize an income of $2,500 or more. It just needs to be demonstrated that the products are worth $2,500. So just give a very basic definition of worth. It is the value equivalent to that of someone or something under consideration, the level at which someone or something deserves to be valued. So again, farmers do not need to show that they've actually realized income of that $2,500 in order to meet that commercial farm definition. Rather, they can show that the products they are cultivating have a value of at least $2,500 or more annually. So that benefits a new farmer, a new farm owner like here, that hasn't had an opportunity yet to actually sell its product. So we had to really take a deep dive into this particular operation and the products grown and understand what it was going on here in order to assess the worth of the products. For this farm, the typical growing season was from April to October. The farmer was growing a large number of 5,000 rare specialty trees, plants, shrubs, and ornamentals during the year's entire growing season. So these rare, high value types of plants was important to our analysis. So the SADC found that the horticultural production occurring on the farm during that 2014 growing season, or the collective increased value of the plants, had an imputed monetary value or worth of over $2,500. So again, we looked at the value of these products, the fact that the farmer was putting work into growing these products and thereby increasing the value, and imputed that the income in order to find that $2,500 requirement was met. This is a photo of the farm itself. It's kind of similar to that farm we looked at the very beginning of this presentation. As you can see, there are a number of competing interests with these residential uses right next to the farm. So public health and safety concerns. The CADB balanced the farmer's interests in what was found to be a legitimate agricultural operation with the public health and safety concerns raised by the township and the neighbors due to the farm's location. Again, you see it's very close to residential properties. The rise in noise level by having trucks come in and out, and the intensity of the traffic. And based on this balancing consideration, the CADB imposed several conditions in order for this farm to receive right to farm protection. Hours of operation, the CADB stated that the farm market shall operate within the hours of 6 a.m. to 10 p.m. This is consistent with the on-farm direct marketing AMP. CADB also required that the work shall be conducted between 5 a.m. and 10 p.m. Monday through Saturday, and 7 a.m. to 9 p.m. on Sundays. That deliveries to the farm shall take place between 7 a.m. and 5 p.m. Monday through Saturday, and that deliveries would be prohibited on Sundays, again, in consideration of the neighboring residential uses. Getting to the noise considerations, the use of backup beepers on vehicles and equipment could only occur between 7 a.m. and 5 p.m. Monday through Saturday, and between 9 a.m. and 5 p.m. on Sundays. And another condition of the right to farm approval was for 15 retail parking spots and 4 employee parking spots at the rear of the property away from the neighbors. All right, so that pretty much concludes this presentation. We on this what's up on the screen is several links pertaining to the SADC's Right Farm program on its website. We list all of our final decisions and all the county decisions that have come down in various right to farm matters. I will say with the caveat, with COVID, and there have been some difficulties with updating our website in the past couple of years, but we're working on getting everything up to speed. So you should certainly find all past right to farm decisions up there, pre 2018, and soon everything will be up to date. So we have a specific site you can go to obtain the decisions related to right to farm complaints. And then we also have a link to, there's one web page where you can find the decisions regarding site-specific agricultural management decisions. And that site is split into two categories. So one chart shows the site-specific agricultural management practice decisions that did get appealed to the SADC, and therefore the SADC participated in that matter. However, there are also a number of decisions which are provided in a separate chart that are just the site-specific agricultural management practice decisions that have been decided at the county level, but they were never appealed. So the SCDC never was able to weigh in on those decisions. So in addition to those decisions, our Right to Farm website has a lot of other resources, a guidebook to provide some summaries of the Right to Farm Act, and also you can get access to the adopted agricultural management practices on that website. So it's rather comprehensive. Again, Right to Farm website contains Right to Farm guidebook and fact sheet. We also have a lot of information about the agricultural mediation program, and have a guidebook and fact sheet pertaining to that program up there as well. You can also find contact information for your local CADB administrator on our website as well. And finally, if you have any questions, you can always call us or email us at the email address that is up on the screen. Any Right to Farm inquiry will get to myself or Brian Smith, and anything related to the agricultural mediation program, Dave Kimmel is our contact as he administers that program. So I believe that questions may have come in during the course of this presentation. If there are any questions, please type them in. And I do want to provide the caveat that since if Right to Farm matters do get appealed, they do come to the SADC and we look at them. We cannot answer any fact-specific questions about your operation and whether the Right to Farm Act would comply to it, because we can't have the appearance of prejudging an application before it's actually in front of us. But if you have any general questions about the Right to Farm Act, please type them in.
Allison, thank you so much.
You're welcome.
And Brian, thank you as well. I mean, Brian was behind the scenes answering all the questions, and this was a really helpful presentation. We'll also put this on our website for your use, and also share it to the registered attendees. So if you wanted to go to our website to find it, you could find it at the foodshedalliance.org.
Okay. I see one open question about the ag labor housing and the municipality having jurisdiction. And it doesn't look more like a question. It looks more like guidance to check with the municipality to get the true answer on whether agricultural labor housing is permitted. And that's right. Right now, as far as agricultural labor housing goes, the only way it can be protected under the Right to Farm Act is if it is for an equine operation and it is for full-time employees, permanent employees, and the housing is in the same facility that is housing the horses. Otherwise, ag labor for other types of operations, under the current state of the Right to Farm law, it is not a protected activity under the Right to Farm Act. And then, all right. Doesn't look like anything else is coming in unless I'm missing something.
Brian seems to have handled all the questions.
Just so that we don't lead anybody astray, the SADC's email address is sadc@ag.nj.gov now. That's an old email address, and we'll have to change that slide for future use.
Yes, our apologies. Here, I wonder if I can type that in the chat box so that everybody has our email address. All right. I think unless Eric, you wanted us to get into any topic a little bit more deeply, that's all we have.
No, thank you. I really think this was very helpful and covered a lot of questions that I think some of the farmers that we work with have. I see a couple chats here, maybe a couple more questions.
All right. Yeah, it looks like they said the email didn't come in. Let me type that in again. Oh, mine, for whatever reason, when I answer, it's only going to hosts and panelists.
Oh, okay.
Here, let me change that. Here, everyone. Okay. I'm sorry about that. I'm typing it in right now so that gets to everybody. Okay, there we go. All right, yeah, and again, any questions, please feel free to email or call us at the SCDC.
Well, Allison, we've gotten a couple of late arrivals. If you want to handle those, you want to handle the monster truck ride question?
I would say no. I don't see how, again, with the caveat that all these things are very fact sensitive. It doesn't seem that a monster truck ride would be related to marketing the output of the farm. So first blush seems like it probably would not be protected. Brian, unless you see it differently.
I don't see it differently. And when people propose an activity on a farm for right to farm protection, as you stated, it's got to be related to the marketing of the agricultural product, but we define what an event is to be subordinate, secondary, accessory, minor in comparison to the marketing of the ag output. So a monster truck ride does not seem to be ancillary, subordinate, accessory to marketing the ag output. The second question is a petting zoo protected under the Right to Farm Act? It's basically the same answer that Allison and I just gave. It's got to be related to marketing the ag product, and it's also subordinate, secondary, accessory to the retail sale of the ag product. The petting zoo may also have some state health issues that need to be complied with. And of course, Allison reminded us all that right to farm does not preempt state law. So there may be humane rules that our colleagues at the New Jersey Department of Agriculture have promulgated. There could be health rules regarding touching the pets and then washing your hands. Off the top of my head, I don't know all of the details, but that's generally the answer for a petting zoo. Allison, did I miss anything?
Yeah, I mean, it's obviously all of the state law components would need to be complied with, and I'm just trying to come up with scenarios where maybe it could be protected. If it's if you're producing llamas and wanting to sell them, and you're using this petting zoo as kind of an ancillary component of marketing, if you're going to actually sell the llamas, if kids, people's kids pet them and they want one at home, I don't know. It can get weird, but yeah, I think you're right, Brian. I don't really have too much more to add.
It just points up the fact that, and Allison said, since we eventually can hear appeals, we have to be careful with our answers as a general matter, if it could be the subject of litigation. But even if it is, these questions are extremely fact sensitive. So posing the question, is a petting zoo protected? We went over the general concepts about a petting zoo and whether it could be eligible. But, Allison raises the point about getting more granular in the answer. And, I hate to say it, but it depends on what we're talking about here. So we got to be a little cagey with our answers.
Yeah, if you question whether something can be protected, that is going on the farm, then you should always contact your CADB, and that's where the facts will get looked at, and that evidence will come to light in order for the CADB to make the determination on the eligibility of right to farm protection. Let's see. All right. Not seeing any other questions.
I think that might wrap us up then.
Okay.
Allison, thank you so much. And Brian, I really appreciate your presentation today and the value it brings to the community.
Thank you, Eric, and thank you and the Foodshed Alliance for giving us this opportunity today.
Yeah, we'll hopefully do this again.
Okay, sounds good.
Have a great day.
Right.
Thank you, everybody.
Thank you, everyone.